Assalamualaikum and good evening to my lecturer. I am Aminun Rosniazhar bin Abdul Ghani. Today I am going to present about this case Muhammad Abdul Hakim bin Embong and Anors versus Sepang International Circuit. In this video, I will be reviewing the case of Muhammad Abdul Hakim bin Embong and Anors versus Sepang International Circuit. This case was heard in the High Court, Shah Alam, and decided by the Abdul Majid Haji Tun Hamzah Judge. In this case, the parties involved are Muhammad Abdul Hakim bin Embong and Nurhaidah binti Muhammad Noor that were representing their son Muhammad Izzat bin Muhammad Abdul Hakim. Meanwhile, the defendant Sepang International Circuit Sdn Bhd as the first defendant and AAM Motorsport Sdn Bhd as the second defendant. This case was brought up by Muhammad Izzat Farah. He was a teenage superbike rider that died due to head injury from a tragedy that killed a safety marshal Satish at the Sepang International Circuit SIC. During the race, they claimed that Muhammad Izzat was involved in an accident when his motorcycle skidded and crashed into Satish, who was in the circuit at the finish line. Satish died at the scene due to the impact of the crash, while Muhammad Izzat fell into a coma and died 5 days later. His parents filed a lawsuit toward the defendants under negligence. The couple claims that the first defendant, SIC, had failed or neglected to provide an efficient and experienced medical officer on the circuit to give medical treatment and assistance during an emergency. They also claim that the first and second defendants had failed or neglected to ensure that no obstacle or individual was at the finish line at the time the circuit was fully utilized by the riders. The issues that were discussed in this case are whether the first and second defendants were responsible for Satish's death and whether Satish or first defendant was negligent. The first issue is whether the first and second defendant are responsible towards Satish's death. The first defendant paid an allowance to Satish as a flag marshal, but not as an employer. Satish did not work with the SIC. Instead, Satish offered his service as a volunteer and was paid an allowance when there was a race. There are no supporting documents that shows the existence of employer-employee relation. The evidence that the flag marshal was a volunteer paid allowance supported by a witness was a flag marshal. However, the judge considered plaintiff's claim by defense on whether Satis is negligent in carrying out his duties as a flag marshal against the deceased. Next, Satis was licensed by AAM instead of AAM Motorsport Sdn Bhd. The second defendant, a witness, clarified that AAM and second defendant are different entities. There are no relationship involved between Satis and second defendant that plaintiff also failed to show it. Insurance on Satis was taken by the second defendant. However, there are evidence show the second defendant was only an administrative arm in this regard to the AAM. Therefore, the judge rejected the claim towards second defendant. The second issue that was discussed are whether Satis or the first defendant as negligent. The plaintiff's counsel argued the insensitivity of the witnesses in the control room by knowing that the deceased also involved in the accident after a minute later. The same ambulance was used to pick up the deceased, although there were 8 ambulances around the circuit area. Plaintiff's lawyer also raised the issue of sending the deceased to Putrajaya Hospital and not directly to Kuala Lumpur Hospital. In return, defendant's counsel stated that it was complied with protocol and that a safety plan had been prepared and submitted to the AAM. Emergency treatment is given as oxygen and drip. According to the protocol, the deceased should be sent to the nearest hospital for further treatment. The deceased was at the medical center for about an hour and was sent to Putrajaya Hospital. The judge stated that there is no evidence presented by the plaintiff whether this action is inappropriate or inefficient, and no proof of negligence occurred by defendants, despite a delay of 7 minutes 30 seconds and using the same ambulance. The deceased was reported stable at the medical center before being sent to Putrajaya Hospital. The plaintiff claim is only to the negligence of the first defendant and does not involve Putrajaya Hospital or Kuala Lumpur Hospital. Plaintiff's counsel also argued that the first defendant, as the organizer, is responsible to ensuring the safety of the riders. Refer to the D28 exhibit about Malaysian Super Series Championship 2013 Sporting and Technical Regulation Motorcycle, which apply to local racing where the rules are held, which must be complied with the FIM rules. He argued there were or tower but were not used. Instead, status was in the track. The defendant counsel refer to the FIM regulation specifically section 1.22.1 that provide this flag will be waved at the finish line on track level to indicate the finish of race or practice season. And Agusatis or D1 did nothing or any violation of the rule. There is no denying that Satis was licensed as a flag marshal. Witnesses of the first defendant explained that Satis' action also took place in international race abroad, and there was even a flag marshal standing, waving a flag in the middle of the track. CCTV footage of the accident was presented, which clearly shows how the accident happened. The issue is whether the acts of Satis waving the flag marking the end of training is in or on the track is allowed or not. If you the section 1.22.1 does not directly touch the post or tower, therefore the failure of Satis to wave the flag from the post or tower, or whether Satis should be in the post or tower, does not arise. The judge referred to the case of Hamzah versus Wan Hanafi by quoting the English case as follows. Common practice by person habitually engaged in a particular operation in strong evidence of what is reasonable care in the performance of that operation. Meanwhile, Lord Anors in Vancouver versus McDavid said, a defendant charged with negligence can clear himself if he shows that he has acted in accordance with general and approved practice. Thus, an accepted habit or habit can negate negligence. Even in this case, the FIM rule themselves state that the flag should be flown on the track and not in the post or tower. The judge found that the first defendant or Satis is not negligent because what Satis did when he was hit by the disease in a practice. Lastly, although the court sympathizes with both those who died as a result of this accident and the plaintiffs lost their children, the court held that the claim against the first defendant or the second defendant was not proven, and the plaintiff's claim was dismissed with cause. In my opinion, I agree with the court decision because the risk of accident in sport like this is very high, but not necessarily when there is an accident, the organizers are automatically careless. This is because accident can also be caused by the rider himself. that wrapped of my presentation for today. Thank you for listening. Thank you.